We are here to present our group presentation about the case TEM versus NSW 2001. Firstly, I would like to thank my lecturer for giving us this case to show our ability as the law student, where Mr. TEM is a plaintiff and NSW police is a defendant, where we are taking plaintiff side. Firstly, we are introducing the three main characters of this case: Mr. Terence Lavender, the driver who collided with the plaintiff car; Mr. TEM, the plaintiff; and the Sergeant Besley, the officer who is at the fault one. On the 11th of January 1991, Mr. TEM, the plaintiff of this case, met with an accident while traveling across Richmond in the western Sydney suburb. Constable Morgan of the Windsor Police Station completed a traffic collision report on the accident, but left blank those portions of the report relating to the blood alcohol content of the driver. Subsequently, in February 1991, Senior Constable Besley, the acting traffic sergeant at the Windsor Police Station, completed those portions of the form. However, he mistakenly recorded the blood alcohol content of the both drivers as 0.14. Acting Sergeant Besley detected the error on the form sometime between the February and late March 1991, at which point he corrected the original report. Sergeant at the Windsor Police Station mistakenly recorded the blood alcohol content of the both driver at 0.14. Later in February, he noted the mistake and corrected it. By the time it was corrected, and a copy of the faulty information regarding the case was obtained by the insurer. It was mid of the 1991 when the insurer admitted the liability. For the further information, I would like to call my friend Prixon.
Hi, I'm Prixon. I'm doing the second part of the presentation. Mr. Lavender had been driving an uninsurance vehicle and Mrs. TEM sued the nominal defendant. The claim was handled by NGI Insurance, which admitted liability on 11 June 1991. The claim against the nominal defendant was ultimately settled on August 1994, with the substantial sum being paid to Mrs. TEM, ultimately settled in August 1994, and the substantial sum being paid to Mrs. TEM. By May 1992, NGI became reluctant to continue paying for the physiotherapy treatment undertaken by Mrs. TEM for the significant leg and back injury she sustained in the collision. This became a source of anxiety for Mrs. TEM, who spoke to her solicitor, Mr. Weller, about NGI's apparent refusal to meet the ongoing cost of the physiotherapy. Mr. Weller contacted the NGI solicitor about the matter. During a conversation in June 1992, Mr. Weller asked Mrs. TEM whether she had been drinking prior to the accident. She had consumed very little alcohol in the previous 20 years, and she was horrified at this suggestion. Mr. Weller told her the NGI's copy of the traffic collision report was both that the error that acting Sergeant Besley had corrected on the original report indicates that her blood alcohol content at that time of the accident was 3 times the lawful limit. Mrs. TEM was alarmed by the information and began to worry about how many people would be told of the determinant effect she considered this would have on her reputation. For the further part, I'm introducing my colleague Amrit.
Hi, I'm Amrit and I'm going to explain more about our case. Immediately after speaking with Mr. Wheeler, Mr. TEM telephoned the Windsor Police Station and was told that her blood alcohol reading at the time of the collision had been nil and that the information on the form was a mistake. NGI solicitor reconfirmed the admission of liability on 29 July 1992. In early 1993, Mr. Wheeler obtained from the police service a formal apology and assurance that the mistake on the traffic collision report had been rectified. However, Mr. TEM continued to believe that NGI reluctance to pay for her physiotherapy was connected with the false information on the traffic collision report. And now I'm going to call my friend for more information about our case. Thank you.
Hi, I am Sudeep and I am going to continue my case. In fact, I believe the treatment was unnecessary. Mr. TEM became obsessed with the mistake on the form She feared she was being punished for something she had done in the past and spoke repeatedly about the mistake with her husband and friend. She found it difficult to sleep and experienced some guilt, stress, and depression, for which she sought counseling. Her psychiatrist, Dr. Michel, diagnosed Mr. Tame's condition in 1995 as a psychotic depressive illness. Mr. Tame brought proceeding in negligence against Constable Morgan and the state of NSW District Court. During the trial, before gathering decision without a jury, it became apparent that the mistake had been made by the acting Sergeant Besley and not Constable Morgan. The court held the state was vicariously liable for acting Sergeant Besley negligence in completing the traffic collision report. Mr. Tame was awarded $115,092 fine, and for further of the case, I'm going to introducing my friend Rajesh.
Hi, I'm Rajesh. I'm here to explain to do my last part of the presentation, which is conclusion. As you know, our case is NSW versus Tame. So in this case, that is labeled under the tort law of negligence, where there has been a breach of duty of care resulting in psychiatric injury of a plaintiff. It is thus explained that a person with normal fortitude became a victim of mental harm, and it would have been avoided. Her psychiatric injury was foreseeable, and the way perception affected her mental health. It was led by defendant's action. Tort law of negligence explains the duty of care cases and its understanding in the functional terms. Negligence law in relation with our case, Mrs. Tame versus NSW, has been presented under the grounds of duty of care, breach of duty, proximity, and damages caused to the plaintiff. Furthermore, number of factors such as reasonable foreseeability and defendant's role in the risk and the harm and in the effect of normal fortitude imposes judgmental weight on the court. Considering all these factors, court had decided to pay a reward as a compensation to Mrs. Tame, accepting her psychiatric illness but denied identifying the duty of care and the degree to which Mrs. Tame claimed her normal fortitude being affected. We agreed to court's decision because whatever Mrs. Tame went through with her insurance company and depression, court held NSW liable and payment of substantial amount and was fair, but the failure of foreseeability test under all factors of tort law of negligence well satisfied court's decision as well. Thank you. This was our presentation on business law on the topic NSW versus Tame. Thank you.